Well, good morning, everybody, and welcome. My name is Kelly Bowl, and on behalf of the Michigan Negotiators Association, I'd like to welcome you to today's learning opportunity, Back to School 2021-22, everything you need to know, almost. I have the pleasure of introducing today's speakers, known by some as Batman and Robin, and we have officially put out the bat signal, more formally referred to as Mr. Kevin Sutton and Adam Walker. Mr. Sutton is well known and well respected by school administrators, thus the Batman title. Mr. Sutton is the office managing member of the Miller Johnson's Detroit office and a member of the firm's education practice. Kevin's a graduate of Michigan State University and the Case Western Reserve University School of Law. Adam Walker is an associate in Miller Johnson's education practice and is a graduate of Central Michigan University and the University of Michigan Law School. In addition to general school law, Adam's practice is focused on labor and employment. Kevin, Adam, I want to thank you both for being here today and for sharing with us any insights you can that'll help us navigate our plans to return to school this fall. Thank you.
Well, thank you, Kelly. Appreciate that kind introduction. And I like that Batman and Robin thing. I think that kind of works for me. Don't fret, though, Adam. Remember, at the last movie, Batman disappears into the sunset and Robin takes over. So maybe that's prophetic in terms of what will ultimately happen here. But I certainly appreciate the nice welcome. Appreciate the Michigan Negotiators Association, which, of course, does wonderful work and has been a great partner for us and our firm for a number of years. We have a very heavy topic this morning because of everything going on and everything we're trying to get ready to navigate. And if things weren't a big enough challenge, another monsoon just rolled across the state and there's power outages and flooded roads and everything else. So I hope wherever you're at, you got a little bit of juice, at least enough to watch a webinar, and everybody is safe and no flooded basements or any of that craziness. So what an ominous setting for to talk about a very heavy topic. And so as Kelly alluded to, happy to be joined by my associate, Adam Walker. And Adam, I could joke and say this is kind of a before and after picture. So this is what you have to look forward to after years of navigating legal problems for school districts. But great pleasure to have Adam join me as always and to chat with you this morning. We're going to try to cover generally 3 topics in the time we have together. We'll see how it goes. I suspect there will be a fair amount of dialogue on these, but we're going to focus first on COVID-19 developments. Understandably, with everything that's going on and the challenges that are confronting our districts, we want to spend some time talking about separating fact from fiction, myth from reality, and what are some of the practical things that we need to do based on the guidance and based on the other resources that are out there, guidance or recommendations, I might say, and how best to navigate those things from a liability perspective and otherwise. We're going to talk a little bit about Title IX, which candidly is a topic that for many districts has sort of understandably been lost in the maelstrom of dealing with COVID the last 18 months. There have been developments last year with new regulations, and then even many developments here in the last 5-6 months with the new Biden administration and even a Supreme Court edict that helps clarify our responsibilities under Title IX. So we're going to talk a little bit about that. And if we have time, we're going to talk about student off-campus speech, specifically a Supreme Court case which just came out about 6-7 weeks ago that finally gave us a Supreme Court standard in terms of how do we deal with off-campus speech of our students. And so that is the roadmap for today. And we are going to start with, again, what is on everybody's mind and COVID-19 and how to move forward. And so we'll start first by talking about what we saw in June and July. So as we were wrapping up a school year like any other, there was some guidance, some materials that came out in June and July. And I'm going to separate that from what we're going to talk about with August, which is only 11 days old, but still plenty has gone in August. But first, let's talk about June and July. And so obviously what we have primarily looked to in terms of our legal obligations as a school district for the last 18 months is the CDC, MIOSHA, the Michigan Occupational Safety and Health Administration, the Michigan Department of Health and Human Services. Everybody's familiar with MDHHS, who largely took over issuing pandemic or epidemic orders after the governor's executive powers were deemed not applicable, and certainly our local health departments. Our counties have gotten involved, and in a large degree, there has been alignment, at least at the state level, in terms of MIOSHA, MDHHS, and in many instances the county. And we've had some degree of consistency over the course of this pandemic. CDC sometimes in line, other times not in line. Obviously, change in leadership and administration on a national level brings some changes at the CDC, but largely we've had sort of consistent messaging during the course of this. June 22nd, the MIOSHA rules that had been issued and the MDHHS order were withdrawn. And so just as maybe a week or so after school got out, for most of us, those rules, that rule and those orders were withdrawn. And that creates a little bit of a vacuum from an operational standpoint in terms of what is the expectation and what are we supposed to be doing. We look and talk about the impact of the MDHHS order specifically being rescinded. And we're really looking at an order from June 1. That was the most recent order. And that order generally required masks for unvaccinated individuals when gathering indoors, which included students under the age of 12, compliance with testing protocols stated in the department's interim guidance on athletics. We all remember the athletics piece as we got into the spring last year and the weekly testing for athletes and all that good stuff. That was withdrawn at the end of June. And so those pieces went away. But what we were left with was an MDHHS sort of reminder, as you see there in the last bullet, that while the statewide mask mandate is gone, they warn that local health departments, establishments, sports organizers, and school districts may have additional rules that must be followed. And so that was sort of where they left it. And if I could comment for a second, that was sort of the beginning, maybe the first domino being knocked over in terms of leaving this at the local level, of making localized decisions in terms of what you think is the best way to move forward. And as we're going to talk about throughout the morning, that dynamic of local control versus state edict versus federal edict, and whether or not you all in the local school districts have been left to fend for yourselves, and whether that's an appropriate thing or not, is a question that I think permeates this entire discussion. It permeates the entire analysis of how do we move forward? Because one thing that I know to be absolutely true is that everybody who works in a school district, everybody who has the awesome responsibility of running a school district wants to do what's best for kids. Yes, we want to follow the law. Yes, we want to make sure we're adhering to whatever mandates have been given to us, but we care about our kids first and foremost. And the idea of local control sounds good, but there's lots of people around us who are also local. And what are they doing? And if there is inconsistency or a lack of cohesion from community to community, that naturally raises questions amongst community members about why is school district X doing it and school district Y is not, or vice versa. And so I would say the rescission of the MDHS order started us down this path of you get to decide at a local level. The MIOSHA rule, as you may remember, these are the MIOSHA rules that I came out, I think, in October, and they were good for about 6 months. This emergency rule ultimately disappears. And so recalling what that said, as an employer, no longer required by rule to do all of the specific things that had been required by the rule, including having a COVID-19 preparedness plan, basic infection prevention measures, health surveillance, work controls, including masking and social distancing, training, and record keeping. And so I think Adam very cleverly put a garbage can on this slide because in essence, that all that stuff went into the trash can and or we call it the circular recycling bin, and disappeared. And so there are still some safety rules in place, and we'll talk about those in a second. But ultimately, this emergency rule, which got a lot of attention, and many of you might have had MIOSHA complaints filed. You might have had MIOSHA people come in and say, you know, what do you have? Who are you requiring to be here in person? Why? Do you have a good faith explanation for those decisions? So on and so forth. To a certain extent, those emergency rules are gone and not something that we have to concern ourselves with going forward. So again, depending on your perspective, more autonomy is a good thing or a bad thing, but certainly the mandates that were contained within those specific rules are gone. So what do we have in terms of workplace safety rules that we need to be mindful of and we need to maintain? We know that MIOSHA certainly has other existing standards for the workplace. Aside from the emergency things that they put in place for COVID-19, there is this general duty clause that MIOSHA has and that they expect us to generally adhere to. And that is specifically our obligation to provide a place of employment that is free from recognized hazards that are causing or are likely to cause death or serious harm to the employee. That is an ongoing obligation that all employers have, and that certainly is still present, though I think we think about serious harm to the physical, or serious physical harm, excuse me, to the employee a little bit differently than maybe we did 18 months ago in terms of what that might mean. In terms of enforcement guidance, what they've told us is when determining if there is sufficient evidence for a general duty clause citation, the employer's COVID-19 program in its entirety will be evaluated. If after considering all the measures the employer has implemented, there still exists a recognized hazard, a general duty clause citation may be warranted. And so what they've told us is, we're still going to look to see, do you have anything from a COVID-19 standpoint, even if we don't necessarily have the prescriptive rule that we provided to you before, do you have something in place in terms of any sort of mitigation, any sort of addressing of employer-student issues, so on and so forth. The phrase that MIOSHA has used really throughout is in good faith. Schools should determine what they need to do in good faith to keep COVID out and prevent its spread in the workplace. Now, I think they recognize that given the mercurial and transmissible nature of COVID, keeping COVID completely out is something that is very, very difficult to do. But have we, in good faith, taken steps to try to maintain a safe work environment? I think that is probably the most general way to say it. Have we taken steps in good faith, or have we just sort of forgotten that COVID exists? I think if we've forgotten that COVID exists and we're not doing anything, they may have a hard time believing that we're adhering to our responsibilities under the general duty clause. But if we have in good faith attempted to control COVID and the COVID spread within our buildings, then we have met the good faith requirement and are not likely to be cited. I will say that even when they had the rule, the emergency rule, and I'm aware of multiple MIOSHA complaints being filed, multiple inquiries, I'm not aware of any citations that were ultimately issued. That doesn't mean that there weren't any out there in the state, but I'm not aware of any that were issued, particularly with the districts that we worked with closely. And so I think ultimately MIOSHA has not been draconian in its enforcement, but it has been certainly mindful of employers' obligations to maintain a safe workplace. Aside from Michigan, we obviously have OSHA, the federal OSHA, Occupational Safety and Health Administration. They have their COVID-19 emergency temporary standard, which is still something that is out there, which applies to all settings where any employee provides healthcare services or healthcare support services. So that's still out there as a standard federally. And we still have Michigan's COVID-19 Employment Rights Act, which I believe, and Adam will correct me if I'm wrong, was adopted in October and is still valid, incorporates the CDC's quarantine and isolation standards, provides protection to employees who cannot work because they test positive for COVID, display the principal symptoms of COVID, or have close contact with an individual who tests positive for COVID, though there are exceptions for that, including for vaccinated employees. And so I know many of you dealt with that last year. We dealt with concerns about malingering. We dealt with concerns about falsification of symptoms, emanating from a belief that we had people that just did not want to come to work. And we were ultimately able to navigate those situations. I won't say it was always easy, but certainly we were able to navigate those situations on a case-by-case basis. And those standards are still there and are still something that we're going to have to deal with for the coming school year. And believe it or not, those 6 or 7 slides just get us to the end of July. And that's before things really started cooking in August. And from there, I think Mr. Walker is going to tell us a little bit about the last very active 11 days. Adam?
Well, thank you, Kevin, and I promise everybody I'm not going to take that long before we let the big guy get back to talking about what's going on and maybe getting the vaccines, or rather the liability here after I talk about vaccines, which is, of course, after I talk about the August guidance. So the CDC at the tail end of July and the beginning of August, on the next slide, Kevin, has school guidance that comes out and says, given the new evidence on the Delta variant, CDC has updated the guidance for fully vaccinated people. CDC recommends universal indoor masking for all teachers, staff, students, and visitors to K-12 schools, regardless of vaccination status. Children should return to full-time in-person learning in the fall with layered prevention strategies, meaning we want kids in seats, but the Delta variant in particular has become such a concern for CDC that even if you've been vaccinated, against COVID and presumably against variants, whether it's through breakthrough cases or what have you, we have a variant that's creating problems. So everybody needs to be masking. And that's not a requirement. That is a suggestion. It's guidance. It's a recommendation. But that's where CDC sits, which was different from June and July, where we saw a continuing recommendation that individuals be masking if they were unvaccinated, but you could rip it off if you were vaccinated. So again, we're sort of in this, as Kevin mentioned, we're sort of in this odd situation where there's a lot of pressure to return to in-person learning, but also you're being left to decide what to do as far as masks. So we can go to the next slide. The CDC guidance itself is not all that different. I feel like by this point, CDC's guidance over the past, oh gosh, I'm losing track of time, but between March 2020 and now, so what, a year and a half has been, it hasn't changed a great deal. It's been, sort of correcting as time has gone on. So everything that you've heard before, you're hearing now again. Those layered prevention strategies are, of course, an emphasis or an encouragement of everybody who can be vaccinated getting vaccinated. Consistent, correct mask usage. There has been a little bit of a difference over physical distancing. The most recent recommendations, and this isn't the first time you've heard 3 feet, I'm sure, but the most recent recommendations do have 3 feet for students and 6 feet between students and staff members, between staff members and staff members, or between students and other visitors. But between students, 3 feet. Obviously, we've had an emphasis on screening and ventilation and making sure everybody washes their hands, coughs into their, mask or elbow or what have you. Stay home when sick, and obviously in the state of Michigan, that's not just a CDC recommendation. That's, as Kevin pointed out, the legislation passed in October 2020, which tells people to stay home if they are displaying the principal symptoms of COVID or have tested positive. Obviously, there remains an emphasis on contact tracing, as well as isolation and quarantine for those who have been in close contact, who have been otherwise exposed, and the cleaning and disinfection recommendations. So that's not anything new, right? What's new in the most recent guidance is, as I mentioned, the universal indoor masking recommendation for all students, staff, teachers, and visitors, whether you've been vaccinated or not. There's also a recommendation that if you are fully vaccinated, if you've had a known exposure to someone with suspected or confirmed COVID-19, you still get tested for COVID. I'm sure the reason for that recommendation has been the rise in breakthrough cases for people who have received the vaccine but are still testing positive for COVID, and particularly the Delta variant. Again, I think the Delta variant is really, I don't have to guess at that. CDC basically said, without using specifically the word Delta, that the reason for this new recommendation is the Delta variant. And who knows what will happen on the horizon with, I've heard about the Delta Plus, I've heard about other variants. It's mercurial is the correct term, as Kevin used. We have no idea what mutation is going to happen next, what the recommendation is going to be from CDC next. We just don't know. We're sitting here on August 12th, and I wouldn't think August 24th, but maybe September 12th, October 12th, we might have something new. Who knows? So there does remain as I mentioned, the CDC's emphasis on in-person learning and safely returning to in-person instruction being a priority. And of course, what CDC thinks is safe is what it's recommended, even if there is no hard line mandatory required nature to those recommendations. We can go to the next slide. So what's Michigan doing? Michigan is, and forgive me, I've got another screen here. I want to make sure that it was in fact just 2 pages. It was 3 pages. I apologize. 3 pages is the length of the MDHHS's recommendations for returning to school. So released on August 2nd, and essentially what MDHHS's school guidance does is it recommends layered prevention strategies, layered prevention measures that one-to-one track with CDC's prevention strategies. So essentially, and this is not anything new, but MDHHS is essentially deferring to CDC's guidance and not recommending any sort of break from that guidance. Similar to CDC, MDHHS is not requiring anything except the work rules that Kevin has mentioned before. But even then, we're talking about statute. We're not talking about MDHHS's any sort of executive order equivalent. So the most recent guidance in a nutshell is essentially said that you gotta listen to your local health department. Because your local health department can, as you all know, require a local implementation of strategies. It can force you to do things, but of course, different health departments are going to do different things. So as you have been, as you did last year, keep in contact. There is CDC's recommendations differ from, so the recommendations are recommendations, but CDC has had in place an order since January of this year, and we have had a few questions about this that have come up recently, so I certainly want to touch on it. CDC issued an order, and it's sort of a mouthful, but it's the requirement for persons to wear masks while on conveyances and at transportation hubs. And what that does is it requires all individuals to wear masks on public transportation, unless your standard exemptions that we all come to know and love at this point are present. So if you're eating food, you don't have to wear a mask. If you're unable to medically tolerate a mask, you don't have to wear a mask. But otherwise, if you're on a bus, you have to wear a mask. And the reason for that, I suspect, is it's the fact that the reason CDC has authority over this is because often public transportation, especially airplanes, trains, and charter buses, travel interstate. So the federal government certainly has authority to regulate that. And despite CDC's commentary in June, that hasn't been rescinded. CDC, after widespread availability of the vaccination, essentially said, look, we're going to look at this order, and we are going to modify it. And they didn't say they were going to rescind it or basically toss it in the trash, but they said that they were going to change it, and that hasn't happened yet. So we'll keep an eye out for that. I can't imagine, given recent developments with Delta, that CDC is really in much of a hurry to change it. certainly not to make it less burdensome or less protective of folks. So we'll see. We can go to the next slide, which I pulled their language exactly from a frequently asked questions document that CDC put out on this, and buses does in fact mean school buses. So if a driver's by himself or herself on a bus, don't need to wear a mask. Just like I'm sitting in my office right now, not needing to wear a mask, but if I go out to the water cooler, I'm around other people, I have to wear a mask. Same deal. If there are students on the bus, if there's anybody else on the bus, everybody has to wear a mask. So vaccines have been a hot topic for a while, and that hasn't changed. We can go to the next slide, Kevin. I have leaned heavily on, a shout out to the EEOC, because I've leaned heavily on their guidance since the beginning of the pandemic for a number of labor questions to see sort of how they were going to enforce some of the guidance that's come out in the last year and a half, or some of the requirements that have come out in the last year and a half. CDC has what you should know about COVID-19 and the ADA and various other civil rights laws document, which has been very helpful. First came out, I want to say, March 17th of 2020 or thereabouts. Last updated May 28th of 2021. So it's been, there have been things that have happened, right? There have been things that have happened since May 28th, 2021. You all are probably sick of hearing me say the word Delta, and I'm pretty sick of saying it at this point, but certainly the Delta variants has caused developments and since May 28th. But the guidance has still been pretty helpful on the topic of vaccines. So it covers a lot of things, but certainly vaccine-related inquiries, mandatory vaccinations, exceptions to mandatory vaccinations are covered in a pretty lengthy Q&A. So big question we've gotten is, can an employer track or request confirmation of or whatever you want to call it, an employee's vaccination status? And the answer is yes. EEOC has been pretty clear on this. It is not a medical inquiry to ask it's not a disability related inquiry, to ask an employee if he or she has been vaccinated, because a person may or may not be vaccinated for a number of reasons, right? Someone may not be vaccinated certainly because of a disability, but not necessarily. They can also be not vaccinated because religious objection or intellectual or some sort of opposition to vaccines in general, kind of opposition that's not religious based. There are a number of reasons. So EEOC said, well, it's not a disability related inquiry, so it doesn't violate the ADA, or it doesn't really implicate the ADA. Now, that having been said, that if you do ask somebody what their vaccination status is, or require confirmation of vaccination, then that it is confidential medical information. So you've got to keep that separately. It obviously doesn't go in their employee file, in their employment file rather. The other thing that you need to keep in mind is just the idea that, well, number one, you can have people who are going to object to that, going to object to that, and certainly you have some obligation to engage in a reasonable accommodation process. I haven't heard of any case where someone says they have an objection to providing proof of vaccination. But I suppose in theory it could happen. And if they do, and at least, I'm not saying that you need to bend to that objection, but you do need to at least have a dialogue about that. So we can go to the next slide, Kevin.
Yeah, I just was going to make a quick comment here, Adam, that,
Yeah.
I mean, if you think about this in the abstract, it makes total sense, right? We're all watching the news. We're all looking at Twitter. We're seeing that there are employers that are requiring vaccination, and Adam's going to talk about mandating vaccination in a second. We see it about, colleges are requiring it. The military is requiring it. Well, if you're going to require it, and Adam will talk about the legality surrounding that in a second, the only way to require it is to track. And so, you're going to have some sort of tracking system in place if you're going to mandate vaccinations. And so, while it's an important point, and we have gotten the question a number of times, and I understand why we've gotten the question, because you could certainly have the tracking without mandating, but the idea that tracking would be legal goes hand in hand with the idea of mandating. And we've all been seeing those media articles come out here the last handful of weeks. So I just wanted to add that, Adam, really quickly.
The other thing that I would mention before I move on to this next bit is, if you have a request, or if you are requesting confirmation of vaccination, make sure you don't ask too many questions. Really, it should just be a very simple provide confirmation of your vaccination or not sort of situation, because the more you start digging into why somebody hasn't gotten a vaccination, the more you are likely to find out it's because that it's disability related. And therefore you trigger your obligations under the ADA. It's not that it's impossible to ask disability related questions under the ADA, but there are certain things that employers would need to show in order to do so. And so you put a burden on yourself if you request too much information, and there's really no benefit to you doing so. So just a simple, show me your card, or show me your, receipt, or whatever, is the way to go. So of course, what's become more pressing in the last few months as the vaccinations become widespread has been the question: can we require our employees to be vaccinated to enter the workplace? And certainly, as public employers, this is going to be, in theory, or at least there'd be a concern that it would be different than private employers, right? Because if you're a private employer, you have a simple at-will employment relationship, and people can either accept your vaccine requirement or they can leave. So there's been a question whether a public employer, particularly with the emergency use authorization for the vaccine currently, whether a public employer can require an employee to be vaccinated and enter the workplace. And reading EEOC's guidance on this, the answer is yes. EEOC has not specifically talked about private versus public, but the fact that they've made they've not pointed out any difference, they've not treated those situations differently, and our own understanding of equal protection laws is that they're really, it doesn't really matter. If you're a public employer, certainly you can require the vaccination for your employees. Whether to do so is less of a legal concern and more of a political blowback concern for that you've sort of been left up to handle yourselves. That having been said, if you are going to require employees be vaccinated, then equal protection laws are going to come into play, as far as if somebody has a religious objection, as far as if somebody has a disability and can't get it, then there needs to be you need to use the interactive process to determine whether there is a reasonable accommodation. And essentially employees are entitled to a reasonable accommodation. Now, what that looks like can be different. Now, whether that's they wear a mask, they work from home, it's the interactive process is more of an art than a science, right? It's more of finding out what solution works rather than having a list of solutions that are feasible in any given situation, because it's so fact specific. Of course, you're under no obligation to provide a reasonable accommodation if the accommodation would be an undue hardship, because at that point it wouldn't be reasonable. Now, as many of you have probably heard me say in the past, or have heard somebody else say in the past, an undue hardship is a pretty high bar to clear. So I wouldn't count on somebody having a request for a reasonable accommodation and then counting on an undue hardship being present. So the last thing I want to mention is that vaccination, if you're requiring it, would also be very likely a term or condition of employment. So if the union comes to bargain over that, when you say all of our employees are going to be have to be vaccinated by October 1st, and the teachers union comes along and says, we'd like to bargain that. Yeah, you're going to have to bargain it. Because people as a condition of employment having to have something injected into them is going to be a hard argument to make otherwise. So we can move on to what I think is the last slide before I turn this back over to Kevin. I just want to note that what you should know guidance from the EEOC is about employees, not students. And so I've personally not had it come up a lot, because if employees being required to receive a vaccination is a political hot potato, students receiving having to be vaccinated is more like nuclear waste. And I understand why many administrators don't want to touch that question with a 10-foot pole. Now that having been said, I think from a legal standpoint, the whether you can mandate students be vaccinated is much murkier than it is with employees, because I think it's pretty clear that employees can be. Certainly from a student standpoint, there have been a number of colleges and universities that are currently mandating vaccinations for students, and recently, within the last week or two, not a binding decision in Michigan, but another federal court decision came out in Indiana that essentially said that colleges and universities can, in fact, mandate vaccination for students. Now, the difference, of course, between colleges, universities, and K-12 schools is you don't have to go to college. You do have to, in the state of Michigan, there is compulsory attendance and an entitlement to education. There's the issue that if you're going to college, usually, not always, but usually you're talking about legal adults, and usually you are talking about that in K-12 situations. So there's the added parent dynamic and the dynamic of parental authority. There's also no explicit legal authority that gives K-12 schools the right to mandate vaccinations for students. Now, there are certainly provisions in the revised school code that I would argue do give school districts that right, and I'm thinking, but they're general. I'm thinking particularly 380.11a and the sort of list of things that K-12 schools are allowed to do, including accounting for student safety, but certainly nothing extremely specific. And then the last thing is the fact that we're still in an EUA situation, right? So the vaccine hasn't been given full approval yet. It's emergency use authorization, and that that may have some legal effect because it's certainly a condition of the EUA that people are not required to take the vaccination, notwithstanding what we've said about the employee situation is different, but here it would be the government as the government, not government as employer mandating it. So the bottom line I want to get across is that if you are considering student vaccinations, you're in much murkier territory than higher education, and it's probably less beneficial to do so. And I'm thinking, when I say that, I'm thinking because the data tends to show, and I understand that the Delta variant has been hitting kids harder more recently, but prior to that, the data had shown that the older you got, the more risk you had of getting it of getting COVID and of being negatively affected to a significant degree by COVID. So sort of the bottom line with that, I am going to turn it back over to Kevin to talk liability.
Yeah, thanks, Adam. And I think important information on student vaccinations, though I'm confident nobody's ready to jump off that bridge yet. We're not even ready to jump off the employee bridge probably yet, but I think you're right that that's something to keep an eye on and likely to become an issue, because let's face it, there are things that we do mandate vaccines for. I just don't know that we're getting close there. So a good insight in terms of where we're at legally. All right, liability. And I'll be honest, Adam and probably some of my colleagues Miller Johnson have been nervous for a week about what I'm going to say here. and my job, largely our job as legal counsel, is to assess risk, minimize risk, and help you avoid risk. We really are all about liability and trying to figure out where it exists and get around it. And I'm going to do my best to talk about liability like a legal robot. I'm not a legal robot. Even though maybe sometimes I need to be. And I'm not going to pretend for 1 second that I don't have an opinion on this topic. I'm not going to pretend for 1 second that opinion is not informed by or persuaded by having a wife that is an elementary teacher who's got to be in a building all day with kids that aren't vaccinated. I'm not going to pretend for 1 second that it's not influenced by having a sixth grader who can't be vaccinated because he's 11 years old. Of course, I have personal feelings on it. And I'm not going to try to pretend that I don't. But I'm going to do my best to tell you where the roadblocks are, what the landmines are, and what, from a legal liability perspective, I think is your risk in trying to answer this question of what do we do? What do we do with recommendations, guidance, not mandates, not requirements, but strong recommendations? What do we do with those? And obviously, we've seen the headlines here the last few days. Detroit's going to require it. Lansing's going to require it. I saw Celine took what I thought was a really thoughtful approach in issuing mask requirements based on grade level, treating those students 6th grade and below a little bit differently in terms of their threshold than those that are in 7th grade and above, because those in 7th grade and above can be vaccinated. And certainly there are lots of other headlines about districts that have made the decision not to require, so on and so forth. The question that I'm getting, and I'm sure Adam is getting as well, from superintendents is, what is our risk legally if we don't mandate masks? We're certainly not violating an edict from the CDC or from the MDHHS, because they haven't given us an edict. They've given us a recommendation. The recommendation is clear, but they've not given us an edict. Before, they gave us an edict, and the expectation would be that we would follow their rules, that we would follow their edict. Here, it is not an edict. It is just a recommendation, and so it does not necessarily need to be followed, despite the way it is worded, which I would agree is strongly worded in favor of having a mask mandate. So if you don't have a mask mandate, what is your liability as a school district? And so I won't spend a ton of time going down this path in terms of the Governmental Tort Liability Act, but most of you are familiar with the concept of governmental immunity, which is outlined in the statute you see there. Absolute immunity to school districts, their school boards, and the superintendent for injuries to a person if everyone is acting within the scope of his or her duties and authority. And so just imagine everybody's at school doing school things. As long as we're doing that, and it's part of the educational program, part of our curriculum, everybody is within the scope of their authority, and there would generally be absolute immunity to the district, the board, and the superintendent for any injuries that might befall someone because of COVID-19. Employees, aside from those people at the top of the food chain, if you will, are also generally immune for non-intentional injuries to a student if they believe they're acting within the scope of their authority. Again, we're doing school things, i.e. we're exercising or discharging a governmental function. And very importantly is that last bullet. The conduct does not amount to gross negligence that is the proximate cause of the injury. You probably have heard that phrase, gross negligence. And gross negligence, generally what we say is school district employees, teachers, building principals, interventionists are protected by governmental tort liability. They're protected, they're immune, they're wrapped in bubble wrap, unless they're being grossly negligent. And gross negligence is defined as demonstrating a substantial disregard for whether an injury occurs. Okay. So if we have staff that are demonstrating a substantial disregard for whether an injury occurs, and the injury occurs, and it can be determined that that cavalierness, that substantial disregard was the reason the injury occurred, then there can be liability. And so what that means is that you're pretty well wrapped. Think of it like a big parka you might wear out in the middle of winter. You're pretty well wrapped. There's a tiny little opening in that parka, and that is if we show a substantial disregard for whether an injury occurs, and somebody can tie that disregard back to them being hurt. So think about this in the COVID-19 sense, right? Are we showing a substantial disregard for whether somebody is injured by not having a mask requirement? That's probably a stretch. Are we doing anything else? Are we doing health assessments? Are we telling people to stay home if they don't feel well? Are we educating our community, though they should be educated now, on what the symptoms of COVID-19 look like? Are we trying to use some of the layered prevention measures that Adam talked about, that the CDC has talked about? Do we have those in place in some form or fashion? If we're doing something, if it's not just like a free-for-all where we pretend COVID doesn't exist, there's a really high likelihood that no one's going to be able to say that we showed a substantial disregard for whether an injury occurred. Even if they could show that, to try to say that that disregard was the reason somebody got COVID would be very, very difficult to do. As we have learned over the last 18 months, identifying with pinpoint accuracy when or where you got COVID is a very difficult thing to do, right? And so I think from a legal liability standpoint, as it relates to governmental immunity, Governmental Tort Liability Act, is there a theoretical risk that somebody could bring a suit and maybe tie it to your substantial disregard? Maybe, but I think it's a very, very small risk. I think it's a theoretical risk, only one that they would write about on a bar exam question, but one that in the real world probably is not a substantial legal risk if you decide not to have a mask mandate. Again, in saying that though, I think looking at some of the layered prevention measures, which many of you obviously had in place last year, maybe contemplating having in place this year, I think will help. It certainly will help. If you're not going to have a mask mandate, having some of those other things as expectations of what's happening in your school environment, I certainly think will help the argument if somebody tries to come forth and say, my goodness, the school's being grossly negligent by not having masks. We can say, well, we don't have masks, but we're doing these other things. I think that certainly will help the argument. And I know that sounds kind of legally and nuanced and kind of specific, but that's really what it's getting down to. At the end of the day, your exposure as a school district, I think, is theoretical only. Doesn't mean somebody can't give you a headache, but it's theoretical only. And I think what buttresses that is some legislation that also came out in October of 2020 from the Michigan legislature. And this is the COVID-19 Response and Reopening Liability Assurance Act, which I've decided to call the CRRLAA just because it's shorter. And what that statute tells us is a person who acts in compliance with all federal, state, and local statutes, rules, regulations, executive orders, and agency orders related to COVID-19 that have been denied legal effect at the time of conduct or risk that allegedly caused harm is immune from liability for a COVID-19 claim. And so what that's saying is, look, if you're doing your best to follow the rules that have been issued, you're going to be immune from a COVID-19 liability claim. That's good news if we're the school district. And what we're talking about here is if somebody's going to come forward because you don't have a mask mandate, they're going to be saying, well, look at the CDC recommendation. Look at what the MDHHS has said. That's what you should be following. They clearly think you need to have masks in school. But what does it say at the top of those documents? It says recommendation. It says guidance. It doesn't say order. It doesn't say rule. It doesn't say regulation. It says recommendation and guidance. And recommendations and guidance don't have the same impact. They don't have the same effect as rules, regulations, executive orders, and agency orders. And one thing that is unequivocally true is that all of these agencies of government have been more than willing to issue rules, regulations, and orders in the last 18 months. And they haven't this time. Now, I could speculate as to why that is, but I don't think that's the best use of everybody's time. The bottom line is we have recommendations and guidance. We do not have rules. And so when I'm looking at this as a legal robot, trying to assess as legal counsel what the risk is to my clients of deciding not to have a mask mandate, my conclusion is that the legal risk is theoretical and relatively de minimis or minimal. That's great, Kevin. What about practical advice? Because I really want to hear your thoughts on this. I think what I would say is this: there is no right answer. There's no right answer on COVID in a lot of ways. And we've learned that over the course of the last 18 months. Every decision has to be made at a local level in terms of what you think is best for your school community. And I'm not going to pretend for a second that that's an easy decision to make. I'm also not going to pretend for a second that the CDC and the MDHHS haven't left most of you out on an island to deal with this issue on your own. And what would be really nice is if somebody would give us a rule or a regulation that we could point to and say, this is what we've got to do, because at least then the board. I think one thing to be mindful of and might want to do is, we'll talk about those in a second. I think one additional thing to think about on this front, and you're going to have people that are upset no matter what you do. If you require masks, you'll have people that are upset. You don't require masks, you're going to have people that are upset, so on and so forth. And so there are obviously going to be political fallout from either decision. I think there's potentially financial fallout from either decision. Kids that will pull their, parents that will pull their kids from the school because they don't like your decision. And they'll send them someplace else where, a decision that they agree with has been made. That possibility exists. I think if there is not a mask requirement, one thing that I am hearing a lot of rumblings about, and I think is very likely to happen, is there is an army of special education parents that are ready to come forth, demand IEP and 504 meetings for their students who are so certified, and make the argument that their child will be denied FAPE if the others around them are not masked. And I think that's a novel argument. I don't know that it's an argument at the end of the day that has legal merit or could ultimately win. But I do know that when we tell them no, there's going to be some of them that go and file due process. There's going to be some of them that go to the U.S. Department of Education Office for Civil Rights. And there's going to be a headache that goes on there, and there's going to be time and money spent. Now, am I saying that that would justify doing a mask mandate? No. I'm not saying that. What I'm saying is understand that that's one of the things that is out there. And as you're trying to assess what the collateral damage will be, and there'll be collateral damage no matter what you do. But if you're trying to assess what the collateral damage might be from not mandating masks, I think that's one very real consideration of what will happen with the special education students on the IEPs and the 504s. And you're going to have your hands tied to a certain extent in that regard. Enough commentary for me. Let's think about practical advice. What must we do? What might we have to do? And what we might want to do. In terms of the must do, we have to know the legal requirements that apply to our school and make sure we're adhering to them. We know that those requirements are relatively minimal at this point. As Adam pointed out, we have to wear masks on buses. That guidance has not changed. And we need to stay in touch with our local health department and stay on top of legal developments. I know many of you are working on a countywide basis, talking to your colleagues across the county, staying in touch with the local health department to see if things change, consistent with current CDC general guidance, not just for schools. We're looking at what the positivity rate is and the spread within counties. And so might we see the counties get more active on this in the weeks ahead? Entirely possible. What might we have to do? Consider what we might need to do to avoid liability and be in compliance with that general duty clause that we talked about. As we've detailed, the back to school recommendations are not legal obligations, but we may want to look at that MIOSHA general duty responsibility to sort of color what we do. Considering continuing or adopting the easy protocols. And here I'm talking about those layered prevention measures again. Make hard decisions in good faith after considering what the guidance is, and keep in mind the current COVID transmission within the community. Be flexible as risk assessment may change safety protocols. One thing we've all had to learn to be here over the last 18 months is nimble. And I know that's hard for our employees. It's hard for our school community. It's hard for our parents. but I don't think we've reached a point where we can avoid being nimble and being flexible. Document or at least be prepared to explain why recommendations were not adopted. Those questions are going to get asked, and that's as much of a legal requirement as it's going to be a public relations requirement. And check your extended learning plan and policies if applicable. If you have extended learning plans that are still in effect, I suspect most of them sunset at the end of the school year. But if for some reason your particular plan extended or had an indefinite period on it with no sunset, take a look at that and make sure that you don't have some obligation or a more significant obligation that you have imposed or the board has imposed through its extended learning plan. You want to make sure that you're covered there. What might we want to do? Take a look at what protocols and procedures have worked. What are our employees thinking about certain protocols and procedures? I do know that there was a statement put out by the MEA yesterday or the day before. I have not seen it yet, but I understand that it's talking about the safety of staff and mask mandates and the decisions that you all have to make within the district. And so I'm sure our employees are not going to be devoid of an opinion on this. Setting aside the concerns about liability, are there concerns or areas of need within your community that would warrant voluntarily implementing or continuing certain protocols or procedures? So those are all things that I think you can think about, things that you want to consider. Question that came up just yesterday, and I added a little bullet here at the bottom. Do we have a duty to bargain these things? And I've had a few people ask this question this week of, do we have a duty to bargain, whether or not we're going to have a mask requirement? And my general response is no. You don't have a legal obligation to bargain. I understand that some unions have made a demand to bargain. I don't think that that's an appropriate step for them to take. Last year when we were talking about asking staff members to do things that they don't normally do, clean desks, clean classrooms, do things that are terms or conditions of employment, that was one thing. The idea of whether or not they're going to wear a mask, to me, is not a term or condition of employment. It doesn't change the workday. It doesn't change their execution of job function. It's akin in my mind to telling somebody at a factory that they need to wear safety goggles. It is a safety protocol. To me, it's not a condition of employment. Now, if we were getting into making them pay for it or something like that, then that might be a different story. But I don't see the decision to have masks or not have masks as a mandate for the school community as something that needs to be bargained. Do I think having a discussion with union leaders is advisable and probably a smart thing to do from a relation standpoint? Probably. I think reading them into your decision-making is not a bad thing to do. But the idea that there's a formal obligation to bargain there, I simply don't believe that to be the case. The other question that has come up here in the last 48, 72 hours, and I don't have a bullet on it, is whose decision is this ultimately to make? Is it the board's decision or is it the superintendent's decision? And I guess I would preface my comments by saying, I don't know that we have any explicit legal authority which says one way or the other. Generally, what I would say is, superintendents have been delegated the responsibility by their board to make day-to-day operational decisions. I think the decision of whether or not to have masks or mandate masks in some or all of your school district is an operational decision. That's Kevin Sutton's opinion. And again, I can't cite any specific legal authority, but to me, masks or no masks is an operational decision, not one that necessarily needs to happen from the board. Practically speaking, depending on the composition of the community, the political dynamic, I can see some boards that want to make that decision. I can see some superintendents that want to make that decision. I can see communities where the board wants the superintendent to make the decision, and some where the superintendent wants the board to make the decision. Again, I don't know that that's necessarily something that there's a bright line rule about who needs to do it. If I was forced to give an opinion, I would say it's an operational decision and one that the superintendent can make on her own. But certainly consultation with and engaging the board in a dialogue on that topic, I think would be very, very important. On the horizon, we'll see what happens. I think we're very unlikely to see broad mandates, sweeping executive orders or required EPSLA, EFMLEA leave. I just don't think that the political will is there, but I won't get off on that tangent. There are several bills currently pending pertaining to vaccines and masks, which emphasize individual choice and limiting employer and governmental safety measures. Those right now are in the theoretical stage. Obviously, the recent movement, including the State Board of Education meeting earlier this week, has been towards deference to local decision making. And so whether we like it or not, right, wrong, or indifferent, I think we are looking at a situation where we're going to have to make the call, and we're going to have to make it against the backdrop that we have just described.
And Kevin, I do want to jump in just for a second. There are several bills in there, as far as I know. I don't think I'm missing any. They're all kind of in committee right now, and so they might die in committee. They haven't been touched since generally May or early June. I think June 3rd was the most recent one, if my recollection serves me. So we might not see any more movement on those at all. I mean, it's at the end of the day, it's the legislature often drafts things that die in committee, and there's no further movement on.
Well, and they're clearly fighting these issues out. We see it down in Texas, where there's been a mandate against mandating masks, and you have some school leaders that are defying that. The governor's office and the AG's office in Texas are filing legal challenges to the defiance. People threatening in Florida to take away salaries, to remove board members if the prohibition on mask mandates is not adhered to. And so this is going to be a battle that's going to be fought all over the country, particularly in those areas where those types of emphasizing individual choice and limiting governmental safety measures legislation is passed. But we'll let them fight it out down south, and we'll wait and see what happens here. So I think I talked about earlier, sort of the first domino being knocked off. Ultimately this is in your camp, and you have to make the decision about what is best. And I don't envy it. I don't envy it as a school law attorney. I don't envy it as the son of a former deputy superintendent, and I don't envy it as the son of a former board president. These are not easy decisions, and everybody, a good portion of your community is going to be mad no matter what you do. And so this is one of those classic instances in which they don't pay you enough to do the job. But unfortunately, it's a decision that you're going to have to make on a local level, because I don't think there's going to be anybody swooping in like a Batman to help answer the question in a definitive way. Unless, as Adam said, we hate saying Delta, unless it continues to explode, and then maybe we'll see a broad sweeping change, but I doubt it. I doubt it. With that, that's enough COVID. Certainly, I'm checking the Q&A. If there's more questions, we can answer them at the end. I do want to talk about a couple of important topics, though, particularly Title IX. And, I'm reminded of that movie with Sandra Bullock, While You Were Sleeping. Not that any of us were sleeping. We've all sort of been in the general days of trying to navigate COVID and educate our kids. But Title IX has had some developments, as many of you may know. And I'm only going to do a couple of slides here just to kind of get you up to date on the latest and greatest. But the new Title IX regulations were announced in May of 2020. Ideal timing, right? 2 months after a pandemic hits. And they took effect August 14th of last year. So almost 363 days ago, they took effect. There was a lot of litigation and legal challenges at the beginning, saying that the rules shouldn't go into effect, that they were flawed, so on and so forth. Those legal challenges didn't go anywhere. There is a general feeling in those that are challenging the rules, that were challenging the rules, that they're way too respondent friendly, they're way too heavily favored in favor of the alleged perpetrator, not the victim. Those legal challenges have fallen by the wayside, and we've pressed ahead. Obviously, we had an election in November. We have a new administration in January. We'll talk about how that impacts Title IX and these new regulations. Ultimately, they've been implemented. We need to implement them in our district. They are not without challenges. They're not without practical challenges, and we have a new battlefield sort of emerging on the Title IX LGBTQ student front, which I will talk about here in a second. So that's a short recap looking at the timeline of notable recent events. And I promise I'll go through this relatively quickly, but there's a ton that has happened in the last 13 months. Starting in June of 2020, so about a month after the new regulations were announced, the U.S. Supreme Court came out with this decision in Bostock versus Clayton County. Now, this isn't a school case, it's an employment case. It actually was 3 cases jammed together, one of which came from right here in Michigan, Garden City, Michigan. RG and GR Harris Funeral Home was packed in with this Bostock case. And what they held was, from an employment standpoint, Title VII has that phrase "on the basis of sex" in it. And the court was answering the question of, what does "on the basis of sex" mean? Does it just mean biological sex? And the court told us in that employment case that on the basis of sex also means sexual orientation and gender identity. Okay. And so what they were doing in June 2020, again, in an employment context, was saying sex is a much broader definition than just biological sex. That becomes important because in the school setting, we're obviously worried about Title IX and discriminating on the basis of sex. We have that same phrase in Title IX that we have to manage from the school perspective. And so we get that case and we say, well, geez, if on the basis of sex under Title VII in the employment context includes sexual orientation and gender identity, does that mean that it means the same thing under Title IX? And that was our assumption. We got some interpretive guidance from the U.S. Department of Ed about 2 months later that kind of said, yeah, with what Bostock said, we think that's probably the case. And then we pressed forward. We had the election. We had some executive orders, which we'll talk about in a second. In February of 21, we started getting all of this talk and dialogue across the country about transgender females being involved in sports equity legislation, and some litigation claiming that transgender females should not be allowed to participate in sports. We'll talk about that in a second. More executive orders from the Biden administration in March. U.S. Department of Education, so now the Biden U.S. Department of Education statements and press releases in June. And then at the end of June, a case that had bounced around the courts for years, the Gavin Grimm case involving a transgender male student in a school district that had banned use of bathrooms other than that of your biological sex. Gavin had won in the Fourth Circuit Court of Appeals. The case was appealed to the U.S. Supreme Court, and the U.S. Supreme Court denied it. And what that means is that the Fourth Circuit ruling stands. The Fourth Circuit ruling was in Gavin's favor, and the Fourth Circuit ruling interpreted on the basis of sex to include sexual orientation and gender identity. And then we get, just a couple weeks ago, the U.S. Department of Ed issued a Q&A on Title IX harassment regulations, where they made it really clear that Title IX on the basis of sex does mean gender identity and sexual orientation. So kind of where we thought it was going all along and where it ended up. And so taking sort of a current snapshot of where we're at within the Biden administration, a couple of executive orders here in the last few months. Executive order preventing and combating discrimination on the basis of gender identity and sexual orientation. Salient language from that order: children should be able to learn without worrying about whether they'll be denied access to the restroom, locker room, or school sports. Seems pretty straightforward, seems pretty unequivocal in terms of what the administration's expectations are. In March, the order guaranteeing, interesting word choice, guaranteeing an educational environment free from discrimination on the basis of sex, including sexual orientation and gender identity. And what that EO called out was the new Secretary of Education, Dr. Cardona. Within 100 days of this order, the Secretary of Ed, in consultation with the AG, shall review all existing regulations, orders, guidance documents, policies, and other similar agency actions that are or may be inconsistent with the Biden administration policy. So what the executive order was calling on was telling the new Secretary of Ed is scour everything the U.S. Department of Education has issued, including the new Title IX regulations. And if there's anything that suggests that it's not consistent with our administration policy, we want you to make suggestions on how to tweak that, okay? What is the administration policy? It's very clear what the administration policy is. It is consistent with what we saw under the Obama administration. It is very focused on marginalized student populations and clearly the issue of LGBTQ students in particular. And irrespective of how you feel about that, that clearly is what's going on, and that's what was happening under the Obama administration. The Trump administration, and again, not a political commentary, generally was less active from an OCR enforcement standpoint during the 4 years of the Trump administration. But what was going on during those 4 years were dozens and dozens of federal lawsuits on this issue. And those suits were coming out time and time again in favor of the students, in favor of the LGBTQ students who were claiming discrimination and harassment on the basis of sex. And so I won't say it's a total about face. It's a little bit of an about face from an OCR enforcement standpoint, but the overall arc of the trend of decisions has been in favor of students for the last couple of years. This U.S. Department of Ed Title IX Q&A that just came out in July, they do say that the amendments that took effect in August are going to be still stay in effect while OCR is doing a comprehensive review. It does highlight the areas in which some schools may have discretion in their procedures. But they're going to be reviewing it. They've made it very clear that we're going to know probably in early 22 what their suggestions for revision are. The bottom line on this, as burdensome and prescriptive and detailed as the new Title IX regulations are that took effect a year ago, we're going to have to deal with them for at least another year. So if you have not looked at your policies, if you have not taken steps to recalibrate your your internal regulations, your internal protocols and processes, you're going to need to do that. If you have not trained staff, if you have not trained administrative staff in particular on Title IX's expectations and how we move through a complaint and what a complainant is versus a respondent and all that good stuff, too much for us to cover here, but you're going to need to do that because we are going to be living with these regulations for at least another school year and possibly beyond that. So we need to be mindful of that. What we've seen on this front in the last handful of months is what I'll call a battle for headlines. I mentioned before these bills that have come out across the country in different states, even federally, looking at sports equity and trying to prohibit transgender females under the guise that they have an unfair physical advantage in sports. We've seen the debate. I won't comment on the debate on either side of it, but why? Why would that issue all of a sudden come up? Because both sides think they can win on the issue. That's why. It's a political issue. And I would say that this LGBTQ student rights has become, I think, the political issue on a national level that both sides think they can win on. That's why there's so much attention being given to it by both sides. And I'm not saying one side plays politics and the other doesn't. I think they both are. And I almost think this is to a certain extent replaced some of the topics of the past that really were political footballs, like abortion and some others, school vouchers. Now it's LGBTQ student rights, and we're seeing that, and that's why there's so much happening on this front. Again, you see the other headlines there, and we've alluded to those, both the Gavin Grimm case, and then that headline, Title IX rule changes expected in May of 22, and those changes will be consistent with the priorities of the Biden-Harris administration. So we have that to look forward to, but we're not there yet. In terms of moving forward, what should the expectations be that you follow? Follow the law. And right now, the law is still those 2,033 pages of regulations that took effect last August. Your policies, your regulation, your training, creating awareness for your staff about what the expectations are and that these things are a little bit different than they were under the old regulations. The standards are different than they were under the old regulations. How you investigate claims, how you document claims, how decisions are made are all different than what you were doing before. So if that's not something that you feel your central office team or your administrative team is up to date on, please, please, please reach out to your legal counsel and find out what you can do to get yourself up to speed and protected as best as possible. So I say somewhat joking, so nothing really changes. Well, everything is changing right now. The dynamic is changing. It is the hot topic. In terms of the regulations, nothing changes for now. Though, again, I expect to read the science and see some changes coming up sooner than later. So little quick snippet there on Title IX. And with that, Adam, I crunched you a little bit, pal. We're going to give you just a few minutes to talk about I think we're calling it Mahanoy. We've got to talk about the Mahanoy decision.
I'll try and give us the very quick and dirty version of this case, but last month, heck, 2 months ago, it's already August. So in June, Mahanoy comes down from the Supreme Court, and I think there was some consternation in the discussions that Kevin and I had from this case because we frankly didn't expect it. But that having been said, I'm going to mention in the end, I don't know how much it really moves the needle from what was already the loss. So you have a student, BL, who was freshman year. She's on the JV cheerleading squad, and she tries out for varsity, and she doesn't make it. They offer her a spot on the JV team. She also tried out for a softball spot, and she didn't make the roster. At the same time, as far as the cheerleading goes, there was another incoming freshman, so being a year younger than BL, who did get a spot on varsity that I think really made her feel unhappy. So the weekend after this happens, BL's at a convenience store with a friend, sends out 2 pictures to her friends on her Snapchat, and as we will see on the next slide, it was there were words used. The first picture has BL and her friend saying, they're holding up their middle fingers and they're saying, blank school, blank softball, blank cheer, blank everything. And, it's sort of like, well, who among us, right? I can't cast any stones. Who among us hasn't felt this way? I mean, maybe not about softball and cheer in my case, but everything, particularly the last year and a half. So the second picture is blank and gives a little more detail on her feelings. It says, basically, I love how me and my friend are told we need another year of JV, but that doesn't matter to anyone else. The context, I think, being that somebody younger than her got in over her and nobody seemed to care. So the pictures on the Snapchat, as can be expected, don't stay with the people who receive the snaps. So the snap gets spread around, and my understanding, I'm not super familiar with Mahanoy, except that it's a small rural district over in Pennsylvania, but it gets spread like wildfire around the cheerleading squad in the school, and they come to the coaches and say, well, we're pretty upset about this, and I don't think we have it in the slides, but there was a statement, a code of conduct that the athletes had to sign that basically said that they weren't gonna, for lack of a better term, be disruptive, cause problems for the program, engage in behavior that's unseemly. So they do that, and under the student does that, and under that theory, the school says, all right, well, you're suspended for a year from cheer. And the student and her mom, not happy about it, say that the suspension from cheer for a year is a violation of the First Amendment rights. Now in the lower courts, the student wins, and somewhat alarmingly, the Third Circuit Court of Appeals had set out a black and white rule that said that it's, in a nutshell, established that if there's speech outside of school and it's not on school grounds, the school doesn't get to have a say in it, doesn't get to respond to it, which in today's world is madness. For lack of a better word, it is madness, because we know how much can bleed between off-campus and on-campus activities, and how disruptive that can be, and how many problems can be caused. So the case comes up to SCOTUS. It's reviewed under Tinker versus Des Moines, which is a very old case law, black armbands. I'm sure everybody has heard about it at one point or another. And the student wins. Using, of course, we always do this. Students don't lose their First Amendment rights, the schoolhouse gates language, and usually the student loses. Usually the government wins. Not in this case. We usually go with a material. If conduct disrupts the school's operations, then it's fair game. The holding of Mahanoy, if there really is one, there is no standard, right? Because First Amendment law is so fact specific, it's really hard to make a one size fits all rule. But if we can sort of distill what SCOTUS says that all off-campus speech is not immunized from school action. There are certain cases where the school has an interest in regulating off-campus speech. Now, those cases, I think on the next slide we have a few, but I'm thinking bullying cases, bullying, severe bullying, and things of that nature that can really bleed out. Things like the use of technology, the school's technology off campus. And we can go to the next slide, Kevin.
Yeah, and Adam, I just want to say one thing. I want to say two things here. First of all, SCOTUS, we didn't all go to U of M Law School, Adam. SCOTUS, Supreme Court of the United States, is what Adam's talking about there when he's saying SCOTUS. And what really got me when this decision came out, and I'm scrolling through Twitter, schools can't address off-campus conduct, off-campus speech. Well, that's not what the case says. So if you take nothing away from this other than dispelling the notion that you can't deal with off-campus speech, you absolutely can. Off-campus online speech can still be dealt with by the school, and Adam's going to detail the holding here in a second. But the headlines that came out that said off-campus is outside our purview as the school district are wrong. Those headlines were not right, and Adam's going to explain why. But if nothing else, know that we can still deal with off-campus online speech as the school, subject to certain restrictions. Go ahead, buddy.
Yeah, thanks for that. So, yeah, I mean, the court's logic here is that the speech was crude, certainly crude, but it was criticisms of the world of which she was a part. It didn't have fighting words. Fighting words is sort of a term of art where they're words so incendiary that basically the world just agrees that the proper response is that somebody punches you because they can't even process what you just said before they react. So that's not present. It was not obscene as defined by the court. So we're not talking about some sort of pornography or anything like that. I don't need to go through all of these bullets, but essentially in the end, the speech didn't actually cause a substantial disruption. And I think that's probably the key. The key is that when there is a substantial disruption, then you can regulate the conduct. And that's been the case since Tinker. Now this case is a little surprising because we've always worked under the logic that an extracurricular activity is going to be protected less than your standard school day activities, but there wasn't really a whole lot of analysis from the Supreme Court about that. So we're in a world where we have to pull back on that assumption a little bit. But otherwise, the core of Tinker is still intact, meaning if there's a substantial disruption, then you're good. You can still discipline that conduct. And if you think that there is, there doesn't necessarily have to be a substantial disruption actually occurring, but you better be darn sure that you have a good reason to believe that one is imminent if you don't have one yet. So it's not purely reactionary. You can do it. You can discipline speech even if it hasn't actually caused the disruption yet, as long as you have good evidence to show that it's about to happen. So that's sort of the takeaway, and we can move on. I know we're sort of hitting our end here, but that's essentially what I've just said. Those are the important takeaways. Look at me, I know what I'm talking about. I do want to say right before we take off, this is a student speech case and not an employee speech case, right? So your standard for disciplining employee speech is totally different. It balances the free speech interests of an employee with the employer's interest in maintaining the workplace, and that's even then it's only after the speech is the person speaking as a private citizen on a matter of public concern. So if someone's in the classroom, they're not speaking as a private citizen. If someone's in the break room and is talking, spreading office gossip, not a matter of public concern. If someone's writing a letter to the editor of their local newspaper about the school budget, all right, you can't discipline that. that's the takeaway is that if it was a coach who was making a video that said, blank school, blank cheer, blank softball, blank everything, that coach no longer has a position as a coach with the school.
Yeah, I think that's an excellent point, Adam. And I guess what I would just close, and we're doing, First Amendment in 11 minutes. It's something we could talk about for an hour. I think when I get through Mahanoy, knowing sort of Tinker and the evolution of the case law over time, I think what is important, and I think ultimately at the end of the day, in Tinker, the student won. They held that what the student was doing was passive, was silent, and didn't disrupt anything. But in saying the student won, they recognized the school could regulate speech in certain circumstances. Here in Mahanoy, the student won. They said that what she did by posting a Snapchat on the weekend didn't impact or disrupt the school environment, but they talked about the ways in which the school could address student behavior that's off-campus speech. So there's really a wonderful parallel. Now I sound like a real legal nerd, but there's a wonderful parallel between how Tinker was decided, student wins but gives the school a roadmap to discipline behavior, and Mahanoy, student wins but gives the school district a roadmap to discipline behavior. And when Adam talked about that bullet of what can they discipline, bullying, threatening behavior, things that are about the curriculum, about education, things that we would expect to create a disruption. Really, when he says not much has changed, that's what he's getting at. The forum has changed. It's Twitter, it's Snapchat, it's Instagram, but the message about disruption hasn't changed. And I think if I were going to say one other thing about Mahanoy, it's the Supreme Court saying, hey, you know that standard in Tinker about substantial disruption? We mean it. Don't get your panties in a bunch about a kid saying F cheer and F softball. But if something really disrupts the school, you can absolutely deal with it. Just like we said in Tinker, but we really mean that standard. We don't mean some lower standard of your feelings are hurt or you think it's offensive or you don't think kids should swear. But if it really creates a disruption, then go after it. Otherwise, leave it alone. And so when he says not much has changed, that's what he's getting at. And I think there is a wonderful parallel in that regard between Tinker and Mahanoy. With that, there were some questions in the Q&A. I think Adam and I largely took care of them. If you want to throw some in now, we can try to address them live. I left us a whopping 90 seconds here, or we can just email you back if you want to throw a question in the Q&A. If you have a question, we can email you back. If not, here's contact information for Adam and I, both direct dial, email, our personal Twitters if you want to hear about speaking engagements and other things. And then I encourage you to follow our Miller Johnson Twitter feed at MJ Edlaw. A lot of good stuff on there on a daily basis. And mjedlaw.com, which we're excited to just be getting ready to launch here soon, but I didn't want to miss the opportunity to share it. You can still go to millerjohnson.com and find us, but MJ Edlaw will take you directly to our education page. So that is the website. Those are the Twitter handles. And with that, Kelly, appreciate as always the opportunity to present. Adam, great job. Appreciate you wingmanning me on this. And we thank you everybody for the time.
Well, Kevin, Adam, on behalf of the M&A Executive Board, I can't thank you enough. We really, truly appreciate the information that you're able to share with us today. I also want to thank Janelle, our M&A Director, as well as Amy and Jeff from Miller Johnson, whom without their support, this webinar would not have been possible. And I also want to share an upcoming M&A learning opportunity. We have our Administrative Essentials, which is essentially a boot camp for principals, assistant principals, and other frontline supervisors. That'll be presented by Bob Schindler, also of Miller Johnson. There's going to be 3 in-person presentations located at Kent ISD, Crawford Ensemble School District, and also at Wayne Risa. And then also our M&A Fall Conference is going to be held in Shanty Creek on October 6th, 7th, and 8th. Registration for these events will be available on the M&A website, where you can also renew your membership if you haven't already done so. And also brochures are going to be emailed this week. So if you could keep an eye out for Janelle's email, that'll provide some additional registration opportunities. And finally, I just want to thank you very much for participating in our learning this morning. And I look forward to seeing you at other future M&A events.